Good afternoon. Hi, everybody. Thank you for coming to the Columbia Journal of Race and Law's 10th Annual Symposium. We are now live, and this is day 2 of our symposium. Thank you to all of our panelists from yesterday, and thank you for all of our panelists that are here with us today, sharing this beautiful Saturday with us in the virtual world. I am Nicolas Galvan. I am the current editor-in-chief of the Columbia Journal of Race and Law. Yesterday we heard from the journal's founding editor-in-chief, and we heard from Volume 10's editor-in-chief as well. We had a keynote from Professor Kendall Thomas in conversation with Katharina Pistor, and we had a panel on contract and property law moderated by Professor Maeve, Professor Etienne Toussaint, Bruce Orenstein, and Professor Conrad Johnson. And today we have our panel on criminal law and how criminal law has underdeveloped racial minorities in the United States. Our panel will be moderated by Professor Shaun Ossei-Owusu, and our panelists include Professor Bennett Capers, Rukia Lumumba, and Naima Gregory. And we will have closing remarks by Professor Alexis Hoag later today. So I'll begin by introducing the panelists, and I wanted to remind everybody during the panel, please feel free to type in questions in the chat, and at the end of the panel, we will have some time for some questions and answers. Okay, so our moderator today is Professor Shaun Ossei-Owusu, and he is a Penn Law's Presidential Assistant Professor of Law with expertise in legal history, criminal law and procedure, civil rights, and the legal profession. He was recently named the New America National Fellow, through which he will work on his manuscript, The People's Champ, Legal Aid from Slavery to Mass Incarceration, which highlights the role of legal aid organizations in longstanding struggles for racial justice. He was previously an academic fellow and a Kellis E. Parker teaching fellow at our own Columbia Law School. Professor Bennett Capers is a professor of law and the director of the Center on Race, Law, and Justice at Fordham Law School, where he teaches classes on evidence, criminal law, and criminal procedure. His academic interests include the relationship between race, gender, technology, and criminal justice, and he is also a prolific writer on these topics. Next, we have Rukia Lumumba, and she is a transformative justice strategist, a human rights activist, and the founder of the People's Advocacy Institute. She works with communities to develop alternate responses to crime and has prevented the incarceration of over 4,200 young people of color. We also have Naima Gregory, and she is a supervising attorney at the Neighborhood Defender Service of Harlem. From 2010 to 2019, she worked as a staff attorney at the Criminal Defense Division of the Legal Aid Society in New York City, where she represented hundreds of individuals charged with a variety of misdemeanor and felony offenses. After our panel, we will hear from Alexis Hoag, who I'll be introducing at that time. Okay, panelists, feel free to take it away. Thanks again for being here with us.
Great. Thank you for the invitation to chat about this important theme. I have a couple of questions that I'm going to raise and give the panelists an opportunity to chat about for a few minutes each, and I'll try to open it up to the rest of the audience and chime in where appropriate. So first, I just wanted to know if all the panelists could spend a little bit of time connecting the work that they do to the theme of the conference. And so my question here is, how do you imagine the work that you're doing as challenging the criminal justice system's historical underdevelopment of Black communities? And so I'll chime in. For me, part of it is just teaching, bringing questions of race, class, gender, and sexuality into the classroom, into criminal law courses. And I'm sure Bennett can attest to this. These are spaces where traditionally these issues typically don't come up. And part of what I hope to do is, help produce lawyers who are conscious to these questions, whether they end up working in the criminal justice system or not. Part of the work that I at least imagine as being responsive to the question that I asked is tied to scholarship and challenging, traditional and common sense understandings around these issues of social identity. And then within that, it was mentioned that I'm working on a book about public defenders. And part of what's important to that work is I think public defenders, legal aid attorneys are traditionally understood as doing work tied specifically to class and poverty and indigence. And part of what I try to do is show how, legal aid attorneys and public defenders have been integral to racial justice struggles, but also aren't immune from the racial biases that we see in other areas of the criminal justice system, like policing, prosecution, judging, jury decision-making. So that's how I would kind of answer that question with a clear understanding. I think there was a piece in the New York Times a couple of days ago that, teaching racial justice isn't doing the work, doing the necessary on the ground work in the trenches, but how I imagine as myself as kind of working toward this larger struggle. And I'm curious about, how the other panelists would connect the work that they're doing in a way that kind of invites the audience to get a better sense of what they do, but also the theme of the conference. And I'll let anyone go first.
I'm happy to go first. It's such a great question, Shaun. And before I answer, I just have to say to the people listening, especially if you're a student, Shaun wrote a piece in the ABA Journal that should be probably mandatory reading for every 1L. So I'm just going to give a shout out to Shaun for that piece. So it's a great question, like what am I doing in my work to really confront this whole history of law as sort of undeveloping sort of racial minorities, the Black community in particular. So I'm going to think about it in a couple of ways. One, in terms of my scholarship, I think it's part of it is simply surfacing this sort of long history. I mean, it's so easy to sort of look at the status quo and look at the current environment and not connect it to a long history and see how everything is connected historically. So, it's impossible to fully understand policing without sort of seeing sort of the history of the slave patrols and how that's part of the culture. It's built into the cultural DNA of policing. It's hard to think of vagrancy laws without thinking of sort of the Black codes and the peonage laws and everything else that were put into place, after the Civil War. Or even how servitude sort of got reinvented under a different name through peonage laws and through the 13th Amendment. So just always sort of trying to connect those things and surface those things as part of the scholarship, I think. It's also part of the teaching, like you were saying, Shaun. But I'm going to add something to the teaching aspect because the older I get, and maybe, I don't know if it's wiser as well, but definitely the older I get and the more I talk to other people, the more I'm thinking that, when I teach criminal law, in a way, I'm complicit in a system that I find deeply troubling. Like I'm still not clear how I can teach criminal law without, in a way, legitimizing criminal law. So that's one of the things I've been struggling with, especially this past year. I guess I will stop there.
I'm happy to go next. First of all, it's such an honor just to be on this panel. I really thank you for the opportunity to be here. Just in thinking about this topic, from slavery to the Black codes to Jim Crow, it's clear that the rule of law has been used to devastate, disenfranchise marginalized people of color for centuries in this country. It is a fact that sentencing guidelines that disproportionately imprison people of color have torn thousands and thousands of families apart and relegated generations upon generations to food insecurity, poor housing, poor education, poor healthcare, and limited access to mental health services. Walter Rodney, in his book entitled How Europe Underdeveloped Africa, writes that development in human society is a many-sided process. At the level of the individual, it implies increased skill and capacity, greater freedom, creativity, self-discipline, responsibility, and material well-being. The achievement of any of those aspects of personal development is very much tied with the state of society as a whole. So underdevelopment is not simply the opposite of development. It is a specific condition that creates a hindrance to the path of development. And I believe that structural racism, mass incarceration, and what I think is the criminalization of poverty are three such conditions. Obviously, you know, the work that I do as a public defender is in an effort to level the playing field to the extent that I can. But like Dr. Capers just said, you know, I can't help but feel complicit in this system that we're forced to operate in. I do think that many people believe that public defenders are anti-racism activists because we represent people of color who have contact with the criminal justice system, you know, that we are involved with racist justice struggles. But it's actually not true. You know, we are actually unfortunately conditioned, fortunately and unfortunately conditioned to do the opposite, to in large part ignore race. We focus on the interest of our clients. And we try to ignore the fact that 90% of the people we represent are Black and brown, and that inmates are still referred to as bodies in court, still in 2020. And so, you know, I found myself also in situations, you know, where I felt compelled to smile or chuckle at a racist joke made by a judge off the record. Because I knew that that judge moments later would be determining whether my client would be sentenced to jail or probation, you know? And so, you know, we are operating within this framework still. And sometimes it is necessary for us to ignore race in some ways, you know, in order to effectively, you know, represent our clients in the best interest of our clients. And so, you know, that's difficult. It's very difficult to grapple with. Obviously, we don't solve this problem alone in the courtroom. There's, you know, other spaces where these issues can be addressed. You know, advancing policy work, et cetera. But, you know, as a public defender, it is very troubling to be put in situations where you cannot acknowledge the elephant in the room because you don't want to prejudice your client. So I will leave it there.
Like, I think I'm the last one. You know, I'm just so grateful for everything that I've heard everyone say. You know, my work as an advocate is what I can consider, or what I do consider, to be the work of dismantling these systems that we are talking about now. So when I went to law school, I went very clearly knowing that I was going to figure out what the loophole was. I knew that I did not want to necessarily spend most of my days practicing in the courtroom as a defense attorney. I knew that I no longer wanted that childhood dream of being a judge, because then I realized what it really meant to be a judge, which was consistently being in a space where you might be forced to lock people up for very long periods of time under very punitive and unnecessary laws that we currently have on the books. And I realized that I wanted to study what the alternatives were. I wanted to study what were some systems outside of the US doing. What were some ways that we can really shift how we look at violence and crime in this country, and began to use alternative models to actually create a system of accountability as opposed to a system of punishment. And so when I went to law school, I felt even worse. Like, I felt even worse after going to my first classes. Like, I just was like, the law is horrible. Like, the law is unjust in this country. It is unjust to women. It is unjust to poor people. It's unjust to Black people, all people of color. Like, I saw no way out. And it just really, and then my clerkship and my practice afterwards continued to teach me that. You know, after I was working I worked at the now tore down Oak Hill Youth Detention Facility in DC, representing young people on institutional charges. And, you know, just even that system of what we felt was a quota system where, you know, they just had to go ahead. They couldn't say that 90% of the young people were not guilty of the offenses that they had been sentenced to. That they literally had a quota system where they had to say that a certain percent were, right? So they were trying to figure out how many people were. You know, like just all of these quota systems, all of the ways that the law actually is not working to help find the truth or justice or even hold people accountable, but actually just set aside to penalize someone, even if they're the wrong person. So the work that I do right now is really focused on developing those alternatives. Here, I'm in Mississippi, in Jackson, Mississippi, where in Mississippi, we have a huge number of folks that are currently incarcerated compared to our population. We have 60% of folks that are currently incarcerated here are Black. 40% of those folks are suffering, 40% of folks that are incarcerated on drug offenses. We have one of the growing and highest rates of aging people in prison. And we see this across the nation, and we've had some of the worst conditions. And so the work that I'm doing is one around decarceration. And so we are working to decarcerate the Mississippi system, which currently has 19,000 people incarcerated. We're working to close down one of the facilities, Parchman Penitentiary, which was the first penal farm in the nation. And it was actually and continues to serve as a prison. After it was a plantation, turned to a penal farm, turned to a prison. And it still exists to this day, 18,000 acres. So we're looking to close that down. We're working to release folks serving mandatory sentences and habitual people charged as habitual offenders. And we're also working to expand parole here. Right now, we're one of the few states that still have the rule that you have to do 88% of your time in prison. We're also working to bail folks out like y'all are doing in New York and everywhere else, right? So we have the only bail fund in the state. And we bail out people all across the state. We bailed out someone for $150 that had been in for 9 months, to a young person that we're bailing out that's 15 years old inside of a Mississippi prison right now in a rural community, who's been there for almost 6 months. And his bail is much higher. And we're bailing him out soon. We are also working to really begin, one of the panelists, I can't remember who it was, and I'm sorry, talked about police reform, police accountability. And so we're working on that too. Jackson is a predominantly Black city. 98% of our police force is Black. And we still have police violence, right? And so the system of policing is not just about color, and I think we all agree that it is a system that was developed to cause harm. It was a system that is developed with a militarization perspective. And so our legal systems allow it to militarize our communities. And so we're working to, one, create a police oversight, a community oversight board of the police here in Jackson. But we're also looking at what does it look like to reimagine public safety? What does it look like to have community-led public safety? So we are starting new programs here, which are centered around community members actually being resourced to provide safety. And we look at safety as adequate housing, as Naima mentioned, safety as a livable wage, safety as ensuring that there are youth development programs and opportunities for young people to engage in some positive activities, which is a huge gap here. So we're looking at programs like the Credible Messenger program. We're looking at violence interruption programs as well to help us mediate conflicts before they become violent. And then I'm gonna be quiet because I can talk about this forever because it really is my passion. Like, it's my love, And one of the things that we realize here in Mississippi is that unlike in some other places across the nation, we have a very significant percent of our population that believes in guns, believes that we need to carry guns everywhere that we go. We are an open carry state, and that's in the Black community, that's in the brown community, that's in the indigenous community, it's in the poor white community, and so what we see is that there are a lot of accidents. And there are a lot of conflicts that could happen without, conflicts that happen that could have not resulted in death had a gun not been present on a person's hip. And so we also look at how does this legal system perpetuate the idea of safety being gun safety. And so looking at even how the courts handle those instances where we see when a white person has an incident of violence involving a gun and it accidentally kills someone, they are treated, a Black person, much different, and an indigenous person here, much different. The outcome is much different. So looking at those disparities as well. And I'll be quiet.
So Shaun, I can't resist. Like, I could listen to Naima and Rukia forever, and I feel so inspired, and I'm, this is just great. And I just have to add, like, part of what I want to do as a teacher is make sure my students are hearing people like Naima and Rukia and learning all of this stuff. I also completely co-sign on to what I hear the two of you saying is also sort of denaturalizing the idea that prison has to follow crime. Like, you could have something alternative to prison. The one thing I want to add that I think I don't do enough of, but I'm trying to do more of, is also denaturalizing the idea of what we consider criminal in the first place. Because, you come to law school and you're taught like, oh, this is a crime, as if it's always been a crime and it always will be a crime, rather than it being very historically contingent and very race contingent. So I think that's one of the things that I try to do to get my students to think like, well, why is this criminal anyway? Like, who benefits, who doesn't?
Yeah, I think that's absolutely right. I mean, a couple quick responses and follow up. To your point, Ben. One of the things I've been thinking about is the relative absence of white collar criminal law and criminal law classes. I was thinking about my class, and I think there were about 4 or 5 cases throughout the whole semester, and part of them were tied to things that were obviously white collar criminal crimes like embezzlement, and what that means for how students leave law school and how they think about what constitutes crime. I think Rukia, I wanted to follow up to say, don't feel like you need to be quiet, because like Bennett, I can listen to you and Naima talk for the rest of the day. I wanted to follow up on this kind of work specific question tied to the theme of the conference, especially since you all kind of occupy overlapping spaces. One of you is in education, one of you is in practice setting, and one is in a kind of practice/advocacy type setting. I guess both of you are in practice advocacy type settings. But I wanted to get a sense of what do you imagine as being some of the biggest hindrances in getting people to understand the fact of racial discrimination in the criminal justice system. So whether it be your students, your colleagues, clients, like I was, again, thinking about what I imagine as being the answer to the question that I'm asking. And I thought, some people just don't want to know, an unwillingness to know. And this is kind of tied to what you were saying, Naima, in terms about people kind of ignoring. I'm thinking about kind of disinterest in doing the hard work of understanding racial discrimination. So a few people who are going to spend their Saturday here listening and engaging in this panel, the challenges of how students are trained to understand the law. And so I'm curious about, in your different work settings, what do you imagine being some of the challenges in getting people to understand the fact of racial discrimination, racial subjugation, and Rukia, I'm thinking about the fact that you said 98% of police officers are Black. I imagine that strikes me as at least being one, but I'm just curious about how you all would think about some of the challenges as it relates to kind of recognizing race and racial subjugation in your different practice work areas.
I think, just looking at the bail system, historically, our cash bail system has held, Black people disproportionately because of the intersectionality between race and economic status, right? And so organizations, like Neighborhood Defender Service of Harlem, we represent, the indigent, and a big hurdle that I have, in court is to really get judges and prosecutors to understand the realities of poverty, and understand that cases cannot be prosecuted in a vacuum without, a full consideration of the circumstances and the economic realities that exist. Recognizing the economic injustice and having the courage to really consider it when determining how cases should be prosecuted. Long time ago, when I just started as a new attorney at the Legal Aid Society, there were these Ward's Island cases. And, Ward's Island is the largest, shelter in New York. And, what would happen is that there was a specific bus that left from a specific location every night to take people to Ward's Island. 90% of the people who were staying at Ward's Island were people who were just released from prison, newly enrolled in programming, just starting parole or probation, trying to get their, feet back on the ground, trying to secure employment, et cetera. And routinely, you'll have the bus driver, out of the goodness of his heart, allow passengers to board the bus without paying a fee, right? And free of cost. And unbeknownst to the passengers of the bus, there would be undercover police officers waiting in the back of the bus until the bus was completely filled and the driver moved off. The officers would then ask the driver to stop and order everyone off the bus and arrest them all for theft of services. And theft of services, is a misdemeanor, and it's it's viewed, viewed as a societal problem. Poverty is, and I think that it's important for prosecutors to, so you, in some instances, a client is charged with theft of services in this situation, arrested in this circumstance, right? And the judge would say, oh, this is a Ward's Island case, dismissed in the interest of justice. And in other instances, the judge would say, but Ms. Gregory, did he pay the fare or not? But this is in fact theft of services, and really just could not separate the economic, injustice from the law, and yes, he can be legally charged with this, but should he be? Should he be? Shouldn't we be having a conversation about the circumstances surrounding this arrest and about the overall economic injustice that exists in our society? But there is no room for that. There's not much room for it. And, to the extent, that I think these arguments must be made to educate judges, like I've been in front of judges who couldn't understand why my client couldn't pay the surcharge or the fee, and it's just like, what, it's $120. Your client can't afford that? No, well, he cannot. a client is homeless, or my client doesn't have access to a telephone, or my client, has been displaced because of, and it is an opportunity though, to again, educate, but after that, there's, not much that can be done to determine, how judges will think about these things and how DAs will think about these things. And, I think that Bryan Stevenson said that the best, we are taught to humanize our clients. That's one of the first things that we learn, as a public defender, walking into court every day, we think about various ways to humanize our client, which presumes, of course, that our client is not considered to be human, at the outset. And, there is a presumption of the inhumanity and the dangerousness of our clients that we have to continuously try to overcome in court. We use education, as a way to humanize our clients, to say, but look, judge, he also went to school, or, he's been working at this organization, he has employment, for a period of time. Like 90% of the people who we represent are indigent, and don't have employment and don't have stable housing. How do we humanize them, and why is it that employment and, degrees are used as a litmus test to determine whether or not someone is human and is worthy of, being at liberty while fighting a criminal case, and so there's just deep sadness in the fact that is the reality, and, but how do we overcome that? I think that maybe proximity is a way. Bryan Stevenson talks about, the importance of proximity, or the role that proximity plays in humanizing the other, getting acquainted with, for example, perhaps it would be beneficial for prosecutors to get acquainted with members of the community that they're prosecuting. Spend time in these communities to fully understand, the systems in which, they are forced to operate, the systems that have in fact failed them and have resulted in them entering the criminal justice system, that have contributed to the recidivism that we see, not because people are opting to go out there and commit crimes every day, but because these systems have failed them, systems that, are put in place. The educational systems have failed them. Like you have Black children that are disproportionately disciplined when compared to white counterparts. I mean, that is the thing. The school to prison, that is a thing, and the school to prison pipeline. And there's a reason for that, and I think that all of us, prosecutors included, especially, really need to fully understand that, right? So that they're not prosecuting in a vacuum, which is what we see over and over again, and it's hard to give like a history lesson and, all of that in criminal court when you're trying to, secure your client's release. It's very, very difficult, and because you're also challenging people's preconceived notions of Black people and of Black poor people. And, that's a difficult thing to do, in that context. And so, yeah, I mean, that is the biggest hurdle, the criminalization of poverty that is not viewed that way by prosecutors and judges, But again, I think that it is a teaching moment. And, there's organizations like NDS and Legal Aid, we exist out of necessity, because the people, who are indigent charged with crimes do have all of these other, collateral consequences, to, contact with the criminal justice system and convictions that also have to be addressed. So our practice has to be holistic, to address how, their employment is affected, how their housing is affected, how, ACS may be involved and they may not be able to, to be reunited with their children. All of these things exist for a reason, because there are broken systems that our clients are existing in. And this is not, this is a reality. And so, that is the biggest hurdle. And of course, we hope that, one client at a time, we're able to use it as a teaching opportunity to create greater awareness in the minds of judges and prosecutors.
Yes, I'll jump in. Thank you for all of that, Naima. That was super, super, super helpful. Got me thinking, as you were talking, all I kept thinking about is the conversation that has consistently been happening here. And that is a conversation around fear, like this great fear that has been ingrained in us as Black people, right? And in our communities, a fear around the harm that will exist based on what we see consistently on the media and to some extent based on our own personal experiences, right? And so, for example, we have been battling here with our city council because the city council has decided to create an order. They've approved an order that allows for people here in Jackson to be arrested on misdemeanor charges and then detained in 2 counties outside of our county because there is a consent decree in our county that says that you cannot arrest people on misdemeanors and then detain them. That instead you can only give them a court hearing for them to reappear in court. Now we've had this same requirement for over 2 years, but now because violence has increased during COVID, we have seen significant heights in the number of deaths in our city. Instead of taking time to analyze why we're seeing that, analyzing the realization that the city shut down for months at a time, forcing people who normally would not be cooped in a room together with each other to be forced to have to exist with each other and no resources to help them navigate or cope with that. Realization that just because it was COVID didn't mean that people weren't going to still be released from mental health hospitals and mental health institutions and not have a place to go, so they're out on the street or forced to go back to homes that can't care for them, right? That has caused additional harm and deaths in our community. A whole variety of reasons. Instead of investigating that, we want to see a fast solution because elders are complaining and scared, rightfully so, right? Because they see young people out on the street who are now driving recklessly. And as they're driving as elders, that's fear, that's causing them greater fear of what will happen to them. And we have seen more accidents, right? We see, young people, reports that young people are, in parking lots, having fun, using that as a space for activity because there aren't any open community centers or facilities or other places for them to go during this time, and there's no open schools. So our elders are fearful and scared that now these young people are going to do things that are reckless to harm them, right? And so there has been this huge push by our community to just lock them up, get them off the street. And so, and it's not all the members of our community, it's members of our community who have bought into that fear, right? And so I think the fear that we allow ourselves, coupled with I don't want to call it a lack of imagination, but it's when you have not been even given the opportunity to vision, given the opportunity to dream, to think outside of the boxes that we know. Our people haven't been given the opportunity to think, what does it look like to actually invest in these community resources that will actually prevent all of this harm, in additional mental health services, in additional housing, in, when we're talking about youth development programs. Instead of spending $500,000 to incarcerate people in another county, right? How do we actually use that money to deal with the root causes of the problems and prevent it in the first place? And so I think that part of the issues and part of the teaching, which I did not feel happened in law school, and I'm glad that we're on this call because I feel like it can be incorporated. And I only got it in my elective classes. That's where I got all of my learning about the alternatives, were in my elective classes. And I think we can incorporate some of this into our core classes. But it's that conversation around exactly what Naima said, around how do we begin to incorporate the history in our practice? How do we incorporate the alternatives in our practice, right? So that when we are going to talk to a judge and defend our client, you know, there's only one courtroom I can talk to you about right now here that I can go in and the judge is going to give you a history lesson around the criminal system and how horrible it is to Black people. But in the majority of the courts around here, you're not going to get that lesson, right? And she's going to make decisions that are based on that history and based on the circumstances that caused a person to get here in the first place. So I think we have to do a lot more education around training folks and having continuing education around training our people, even as advocates, as attorneys, and as however we're going to engage in this legal profession. We have to start to educate our folks around what does it mean to help our people look at the circumstances that caused us to get there, analyze that, and then also analyze the reality of how we can interrupt this system. How do we interrupt this system? And you can interrupt this system whether you're going into legal defense or whether you're going into, legal criminal defense or as a prosecutor, or if you're going into some corporate setting where you're not even engaging in so-called baseline criminal defense. You're engaging in some type of, other law. It's always ways to interrupt because race and class is always going to present itself. And so, yeah, I'll be quiet. I have so much more to say, but go ahead. I want to hear Professor Capers. Yeah.
Like I said, I could keep listening to the two of you for a long time. The only thing, so I'll add, listening to the two of you, it actually brings me back to how the criminal law plays a role in sort of underdevelopment. And it also brings me to my favorite critical race theory question is always asking like, who's benefiting and who's not benefiting? And it seems to me like, Naima, listening to you talking about arresting poor people for theft of services, all I could think is, well, who's really benefiting from this? Because we see the Black people and the brown people are not benefiting, but my guess is, I'm always thinking, well, there are people benefiting. They're benefiting. Like I wrote a piece like, people like having whiter cities. They like not having to see Black and brown people, especially if they're poor. Even in New York, when people were, fighting over stop and frisk, if you look at polls of polling white people, how they feel about it, and Black and brown people, you get a very different response because, okay, well, some white people, we're like better off if the situation, we're better off if people are arrested. And to Rukia's point, white people might be better off if Black people are afraid of Black people. So I think, part of the education is educating first Black people, like how the whole system is set up in a way to sort of underdevelop them. I also want to go back to Shaun's question, because when Shaun first asked this question, my first thought was, on the biggest hurdles. I thought of Jennifer Eberhardt, who teaches at Stanford, who does psychology, and her studies, which I think everybody should be aware of, like she did studies where it's basically going up to white people on the street and saying, oh, 3 strikes laws is bad. Would you sign this petition to oppose it? And what she found is, whites, if she just says, oh, will you oppose it? Whites are inclined to say, yes, they'll sign a petition. But if she adds, and a lot of Black people get caught in 3 strikes, all of a sudden it's like, oh, well, I don't know, maybe it's a good thing. Maybe there's nothing wrong with 3 strikes laws. So it's almost like even bringing race up to white people can backfire, where they're like, okay, well, if there are lots of Black people in prison, then maybe that's okay. How do we fix these things? That's what I think that's what all of us have been trying to figure out all our adult careers.
And I just want to say that I think that, a part of the problem too is that there's such a disconnect, when, you're prosecuting from the perspective of, punishing those people over there, those people who commit crimes, as opposed to those people who once released, are going to return to our community. it's not from the perspective of, you know, prosecuting people who are members of our community. It's just prosecuting people and taking them out of, you know, our community, you know, if that makes any sense. It's not a holistic approach to prosecution. It is one of othering, you know, and because of that, we've never been forced to grapple with, well, how do we deal with the fact that there is little access to mental health resources? How do we deal with the fact that there's a poor education system? Because we've never been forced to deal with it, because our solution up to now has been lock people away. And so when people are locked away, they're out of sight and out of mind. And one of the most interesting things that have recently happened, as you guys know, with the new bail reform, you know, on April 2019, New York State passed sweeping restrictions to the use of money bail and pretrial detention, ruling out their use for nearly all misdemeanors and nonviolent felony charges, right? And so, you know, it went into effect January 1st of this year, shortly before the pandemic hit. But it meant that close to 9 out of 10 cases, you know, people were being released in large numbers, you know, and in fact, it contributed to a 40% decline in New York City pretrial jail population. But then when crime began to spike, you know, during the pandemic, there's outrage. Now we have all of these people on the street. That's the problem, because of the bail reform. You're letting all of these people out. You know, and this extreme outrage over the reforms in the midst of the pandemic wasn't just about fear of hundreds of Black people being released on recognizance, but the fear of poor Black people. You know, like those people who are presumed to be dangerous and ill-intentioned because they happen to be afflicted with chronic homelessness, mental illness, and or drug addiction. Black poor people who finally have the dignity of making critical decisions about their case while at liberty are at the same time vilified by a society who would rather lock them away, out of sight, out of mind. You know, and I think that, you know, it's interesting that the confluence of the pandemic and bail reforms, I think, have forced us to confront these issues of poverty, poor access to mental health resources in a way that, you know, we've never had to do before. You know, so it's a very interesting time because, you know, now there's no hiding from it. You know, like we really do, these resources need to be provided. And it's not just throwing resources at communities, obviously, it's about investing in those communities and empowering those communities to take care of themselves and you know, empowering them to make the decisions about how they should be policed and how their issues should be addressed. Yeah. So yeah, I mean, I think that, you know, it's, yeah,
I just was gonna add, you know, look at the similarities. While that's happening in New York, it's also happening in Mississippi. And it's all in a response to an increase in violence. That's literally the same exact thing that I just talked about in terms of this new ordinance that says, oh, we're going to lock up folks on misdemeanors and then detain them in another jurisdiction because we can't detain them here, right? And it's like a correlation of a fear response to violence as opposed to a logical response to the increase in violence. And so, yeah, I just appreciate that because that was super helpful in terms of seeing it across the nation and a recognition that violence has spiked everywhere, right? It has spiked everywhere because we have a system that does not invest in people, right? And in our communities. Yeah.
So I'm just I can't help but resist to think like also this sort of focus on Black and brown poor people so often is misdirected. So I'm segregating out like the violent crime. I keep going back to that bus in theft of services, Naima, because I'm thinking, well, just in 2008, when we had the biggest economic collapse this country has seen in decades, you know, all the big shots were too big to jail. Like that's causing so much more damage than like somebody getting on a bus for free. And yet we're sort of brought up to think like, oh no, the people getting on a bus and not paying 50 cents or whatever it is, somehow that's more harmful to me than the fact that, you know, I might lose my house because of what people did with mortgages. I mean, that's absurd.
I actually wanted to follow up on that. We have about 10 minutes. And I have a bunch of questions, but I'll just combine them into two and then try to leave some space if anyone in the audience has questions. And so the first is just about a question of how do you think COVID has altered or disrupted how people think about the criminal justice system, if at all, if it's opened up any kind of possibilities. And the second is, I think the protests of the summer have forced the kind of general public to have its own racial reckoning and kind of understanding of the role of race in the criminal justice system. And I wonder, given what we know about American history, if you think that this is a kind of like pivotal moment, or if it's just temporary and or ephemeral. So the first question is about just kind of COVID and the criminal justice system. And the second is, like, does this feel different and pivotal? Or is this just do you see this as part of the ebb and flow of the role of race in the United States?
So can I go first? I'm just going to address the second question. I think it felt very pivotal, but much less so when a presidential candidate used coded law and order rhetoric to get 70 million votes. So I feel like, okay, we're almost back where we started.
I'll jump in. So I will answer the first question first. That at the beginning of COVID, I feel like we were actually in a place where we began to see people, we actually began to see more decarceration, right, at a massive rate. We saw folks being let out of jails in mass, right, across the nation in many places. That was on the heels of several different uprisings inside of prisons, right? And so like right during these uprisings, we then saw people being released from jails, right? And we then continued to see a push for a couple of months after that for folks to be released. And then as soon as violence started to spike, we saw a complete reverse. And I think that's the same that we can say when we talk about our movement in the streets. Our movement in the streets have been consistent for over a year. People standing up and speaking out, and for longer than a year, for decades, but has really grown over this past year. Millions. This is the largest, literally, the Black Lives Matter movement has been the largest in U.S. history, the largest by numbers in U.S. history. And it has galvanized people and started a conversation around policing, regardless if people agree with the term defund police. It has started the conversation in a way that it cannot be ignored and was center in the presidential debates and so forth and so on. That hasn't necessarily happened in history before, right? And that's important. That's a win for us. So I do believe that it is a pivotal moment. But at the same time we had that conversation happening, we also then saw again, the reverse began to pop up as we get closer to November. This conversation around defund being dangerous because we need police, because we see an increase in violence. And what we forget is that the Black community is actually very conservative a lot of times around a lot of issues. When we're at home and having conversations with our people, we know how conservative our folks can be, right? And so we don't necessarily vote conservatively, right, on issues unless we feel it is necessary, right? And so, I think that what we see happening is not just a problem with the system. And when I say the system, I mean the system of criminalization in this country, but also a system of electoral politics in this country, a system of capitalism in this country that holds on to this idea of a fear-based analysis of what needs to happen, how we respond, and how we educate people. And so for those of us who really believe in an education that helps us realize something bigger than just a response, and actually to be proactive and preventive and always work on the offense, what I think that we have to do more of and have to do a better job of is educating our folks on the front end, of having these conversations about what does it look like to have bail reform in communities. And I'm not saying that that didn't happen, for example, in New York. I believe it probably did. I don't know. But like for sure, in other places across the nation, what does it look like to get our people on our side around bail reform before we actually just push the policy, right? You know, and so like really holding our people central to our decision-making process and not peripheral. Let's not engage in the same practices that we see our politicians engage in, where they create the policy and then tell us what the policy is, and now we got to fight against it. You get what I'm saying? And so, so that's what I'll add about both. But I do think this is a pivotal moment. I think our people are ready. I think our people are more ready than they have ever been in the past or in the recent past. I think our people are ready to be educated. They're ready for something different. And they have shown us through these elections that they're not only interested in a change, but they're interested in issue-based change. They not necessarily caring about who the candidate is per se, as long as these people are going to fight for the issues that we hold to be important to a better quality of life. And so I think we're ready.
Yeah, I completely agree. My only hope is that, you know, these months and months of protests will translate into people truly educating themselves, you know, educating themselves about the history of the country and how the country was built. And, you know, the place of minorities in this country. And I think that once you do that, that is the place to start. There has to obviously be a reckoning of the original sin, you know, chattel slavery, to really understand what that meant, you know, not just for the people who were enslaved, but what it meant economically for this country in terms of, you know, how, you know, certain institutions were able to benefit from that. And I think that without that understanding, then we can't move forward. So I'm heartened to see like so many, you know, people of all races, you know, in the streets protesting, and, you know, people genuinely concerned about these issues, bringing their children and educating their children about these issues. I think it's generated interest in public interest work, which I think is fantastic. Of course, this is necessary work. And I think, you know, finally people are open to reimagining what, you know, policing, you know, and you know, a lot of what we did, you know, during the pandemic was, you know, file writs of habeas corpus to get, you know, or clients who had underlying medical conditions out. And, you know, what that did really was force an analysis of those conditions, you know, and it really put a microscope, you know, on Rikers Island in a way that I think really didn't exist before, really scrutinizing the conditions under which inmates are forced to live, you know, and even worse, you know, during the pandemic, you know, guidelines that were just not being followed. Well, because they're inmates, and, you know, why do we have to put these mechanisms in place to keep them safe, to keep them healthy? And so, you know, that really was, you know, it forced the conversation about whose lives or whose life deserved to be valued, you know? And so, yeah, the point is that I think it's an interesting time. It's ever evolving. And I hope that it just ultimately results in, you know, not just an interest in this work, but really like truly, you know, an interest in educating ourselves and then educating our children, and then change, you know, having it, you know, affect, you know, the way courtrooms operate, you know, making the courtroom space a space that is open to that kind of conversation. And hopefully this kind of, you know, conversation will take place in law schools as well, so that that conversation can start there.
Well, we have just a couple more minutes. I wanted to leave some time for the audience if anyone has any questions. And Jake, I think you're fielding the questions.
Yeah, exactly. And before just reading off a question that I received privately, thank you all for that really, really incredible conversation. I did receive one question. So this is in response to 2 points I think several of you made near the beginning of the conversation about being in situations as lawyers where we have a duty to be silent about important issues related to race in the interest of our clients, and sort of how we navigate that line and sort of navigate that sacrifice in sort of day-to-day lawyering.
Was that for me? No.
Oh, that was just a general to anyone who wants to take it.
I'll just share a quick story, and then I think maybe Naima, you want to take it. I don't know. But quick story is that oftentimes my father, who was a criminal defense attorney before he ended up becoming mayor, and then he passed away, but he would often find himself in a situation of contempt of court. And over time, over a series of years, not only because my mother said, I'm not bailing you out anymore, but also because, he recognized the harm that it would made due to his clients over a period of time. He had to be more, he had to have more of an analysis around when it was good to do that and when it wasn't. And there were absolutely some times when being held in contempt of court was necessary. It was necessary to meet the ends of showing that this judge was completely racist and causing a problem and was hindering his client's ability to have a fair and just trial. And so there were certain circumstances where he absolutely just went ahead and did it. The last time that I can remember he did that, while I was in law school, and he told the judge was preventing him from presenting a motion. And it was something that was regular that every court would allow you to do, and the judge just was not letting him do it. And so he said, well, Judge, if I got to pay for justice here, then I will. And he threw $100 at the bench. And the judge held him in contempt. And then the bar pressed charges against him. And he ended up, this was his second time in threat of being disbarred for zealously advocating for his client. And this time they actually did suspend him for 6 months, right? Every other time he had won. But at the same time, his client actually benefited tremendously from that because he ended up getting a new judge. And then he ended up having his case actually become successful at the end. And this was a person who was in jeopardy of life in prison. And so sometimes, we just have to weigh the cost, have to do a cost analysis, weigh the risk and the benefits. I share that. To say, don't always be scared, but weigh it.
That's such a difficult question. I mean, I think that it's very important to know your audience. It's very important to study the judges that you intend to appear before, and also the prosecutors. I mean, the primary goal, right, obviously, is to zealously advocate, on behalf of your client. That's your job, and whatever it is that needs to be. And I'm not saying that it needs to be done at all costs, right? I'm saying that there are outrageous things that happen that force you to not respond in anger. But really force you to then find a way that you can use that circumstance to educate. Because that's really the only way that we move forward, right? To use it as an opportunity to connect, with the judge or the prosecutor who has an outrageous view, and to just explain why they're mistaken, or why it should be viewed differently, and it does take a lot of experience and introspection to get to a place where you can do that. But it is necessary for you to do that. Not just because of, the greater purpose of, educating judges and prosecutors, but also, the short-term effects, for your client. It behooves you to step outside of yourself, and think about that, think about ways that you can educate without offending, educate, without prejudicing your client. And it's hard, because sometimes you feel disrespected, as an individual attorney, but it is necessary to step outside of that, and, you just stay focused on the bigger picture, right? Which is, being a zealous advocate for your client, ensuring, the most, the best result, the best disposition that you can possibly get, while, not destroying, relationships that you have with the court, and with prosecutors, because these are the same judges that you have to appear before over and over again. These are the same prosecutors that you have to, work with over and over again, so it's really kind of like a dance that you perfect over time, but it's all about relationships, and these are people, people, with their own preconceptions, about or clients, about people of color, about poverty. And I just think that, again, it is just time and time again, an opportunity for us to educate and for us to connect, because that's really the only way that we move forward. And if there's ever an effort to change the criminal justice system from the inside, I think that's how we do it.
Can I just add one thing? That for some additional support and guidance around that, especially when you find yourself in front of a judge that just is known to be, racist and biased in so many ways, is, in joining an organization of lawyers, right, that also are going through similar things. So, like Law for Black Lives, you have the National Conference of Black Lawyers, you have the National Lawyers Guild. I mean, there's so many institutions that I think that are really powerful at movement lawyering, right? What it means to actually use, your position to move us towards something different.
Thank you all again for answering that and for your really wonderful conversation. We did get one more question about inviting people into movement lawyering and addressing issues like mass incarceration instead of corporate law. But I think given the fact that we're running a few minutes over, we might have time at the end of Professor Hoag's closing remarks to maybe, she might be able to answer that question as well, rather than answering that now. So thank you all again. And I believe Nico will now be introducing Professor Hoag for our closing remarks.
Yes, thank you for that panel, bringing a lot of memories of my 1L year. Just a lot, my classes left a lot of gaps, and I'm glad that we have the space to discuss that. But now for our closing remarks of our symposium, I have the pleasure of introducing Professor Alexis Hoag. Professor Hoag is an associate research scholar and a lecturer in law at our own Columbia Law School. She serves as the inaugural practitioner in residence at the Eric H. Holder Jr. Initiative for Civil and Political Rights, and has directed practicums on abolition and capital post-conviction defense. Professor Hoag has spent over a decade as a civil rights and criminal defense lawyer, including as senior counsel at the NAACP Legal Defense and Education Fund. Professor Hoag.
Thank you. I wanted to start by thanking the Journal for Race and the Law for inviting me to deliver closing remarks at what is now the 10th annual symposium. I'm honored and I'm humbled, particularly relative to these fantastic scholars and thinkers who participated last night and obviously just before me. I especially want to recognize this year's symposium organizers, Jake Elkin, Nicolas Galvin, and last year's Ibrahim Diallo and Amanda McNally. Ibrahim was one of my students, and Amanda, they first approached me with their thoughts on Manning Marabel's powerful work in January of 2020. They initially planned for a convening in early April of this year. However, it's fitting, really, that our symposium is occurring now. And it's as the nation braces for this second wave of the pandemic and in the wake of the presidential election. Georgia recently reconfirmed that, yes, indeed, Biden and Harris won the electoral votes in that state. But both events really exposed long-standing structural damage to the nation's foundation. Damage that the law's underdevelopment of segments of the population cemented. We continue to witness the lethal impact that COVID-19 has had on under-resourced communities of color. Due to generations of unequal access to healthcare, Black people experience higher rates of the very illnesses that make them most susceptible to the illness: diabetes, hypertension, sickle cell disease. After the US Supreme Court gutted the Voting Rights Act of 2013, we continue to witness states like Arizona, Georgia, Texas close early polling locations most utilized by Black and brown people. By almost every measure, health outcomes, education, access to wealth, contact with the criminal legal system, the condition of racial minorities in the US and Black people in particular is in a state of underdevelopment relative to white people. Each of the speakers at this symposium has explored and interrogated the intertwined relationship between the law and the underdevelopment of racial minorities. This is a powerful framework from which to hold these discussions. It both acknowledges the law's central role in maintaining white supremacy, and it urges us to question the legal standards and norms that the law presents as neutral. Over the next 15 or so minutes, I'd like to discuss three areas. First, I want to tie together some of the concepts raised throughout this symposium. Secondly, I want to examine the law's unfulfilled promise to deliver redress to Black victims of state violence. And I'd like to end with an exploration of abolition as a theoretical framework to dismantle the law's chokehold on Black people and other racial minorities. I really want to pick up where this last panel has ended. So first, yesterday, Professor Kendall Thompson, in conversation with Katharina, Pistor, recognized the role of the law in designing and maintaining what Professor Thomas calls an architecture of underdevelopment with respect to capital. We were introduced to Professor Pistor's book, The Code of Capital, where she refers to the law as the cloth from which capital is cut. And if I may extend that metaphor, despite the labor of enslaved people to turn the cloth into goods, the law denied Black people from reaping the benefit of those goods. Professor Thomas then explained that the law prevented people of color from availing themselves of the power and protections that the state offered. Next, we heard from Professor Maeve, who examined underdevelopment in the context of property and contract law. Professor Conrad Johnson and Bruce Orenstein shared personal accounts of how underdevelopment impacted their families, one Black, one white, with access to educational opportunity, capital, and the accumulation of generational wealth. Professor Etienne Toussaint explained that contract law served as a tool to legitimate the underdevelopment of Black people. Following emancipation, the government extended the freedom to contract to Black people, many of whom, with no other option, bonded themselves into sharecropping contracts. And just now, we heard from Shaun Ossei-Owusu, who led a conversation on the criminal legal system's underdevelopment of Black people, with Professor Bennett Capers, Rukia Lumumba, and Naima Gregory. They reminded us that we cannot discuss inequality within the criminal legal system today without first acknowledging the history of slavery, Black codes, and Jim Crow. Professor Capers encouraged us to denaturalize the conduct that we consider criminal. Rukia and Naima called upon us to reimagine public safety without propping up and legitimizing existing criminal law. I'd like to discuss the law's unfulfilled promise to Black people as it relates to state violence. Before emancipation, the law generally did not recognize harmful acts committed against enslaved Black people as crimes. Property law provided the only available means of redress, enabling an enslaved person's owner to collect compensation for damaged or lost property in the event of an enslaved person's death. The law treated Black victims as a legal invisibility. The same was not true for Black perpetrators of violence. For even relatively minor infractions and where the victim was white, the law punished Black people with death. In this way, Black lives did not matter in the eyes of the law. Reconstruction, what Columbia historian Eric Fauner refers to as the nation's second founding, had the power to change this. It recognized Black people. Sorry about the background noise in Harlem. It recognized Black people as citizens and codified laws to prohibit the denial of their rights. Yet anti-Black racism derived from slavery runs in the very DNA of this country. Underdevelopment of racial minorities and white supremacy are what this nation was founded and expanded upon. Notably, our Constitution frames civil rights in the negative, rather than as a positive. The Reconstruction Amendments did not bestow new rights upon Black people, rather they removed race and the status as an formerly enslaved person as a barrier to citizenship, and then prohibited others from preventing citizens from exercising their civil rights. But once citizenship included Black people, the law permitted discretion and the development of jurisprudence to exclude Black people from protection. Reflecting on Reconstruction, Frederick Douglass observed, "The arm of the federal government is long, but it is far too short to protect the rights of individuals in the interior of distant states." The first Supreme Court case to test the reach of the Civil Rights Act of 1866 and its federal authority was Blyeu versus United States. In 1866, two white men attempted to rent a room in Kentucky from a Kentucky boarding house. 3 generations of a Black family ran this house, including a 97-year-old grandmother who was blind. When the family refused the men, they came back and slaughtered 3 generations of this family with an axe. The only witness to the crime were the Black surviving members of that family. Because Kentucky law prohibited Black people from testifying in court against white people, the local U.S. attorney, armed with this new Federal Act of 1866, removed the case from state court and tried it in federal court, securing convictions and death sentences against those 2 white men. On appeal, the U.S. Supreme Court reversed, holding that the surviving witnesses were not, quote, persons affected under the law, and therefore the lower court lacked jurisdiction to indict the defendants. Since the affected persons were no longer alive, the federal court could not uphold their rights. The court's early evisceration of the Civil Rights Act of 1866 prevented it from being a viable tool to provide redress to Black victims of state violence. Notably, parts of the act today serve as the foundation for 18 U.S.C. 242, which is the criminal equivalent to Section 1983. These 2 contemporary federal statutes are intended to provide redress when state actors violate the rights of Black people. Beginning with the court's ruling in 1871 in Blyeu and continuing today, the law has failed to fulfill this promise to Black people. Lastly, I teach a class in abolition, and I want to provide it as a tool to dismantle the law's chokehold on Black people. My comments in abolition are in direct response to where Rukia and Naima's call to reimagine public safety. Abolition is a theoretical framework that invites us to examine how this nation's history of slavery, the racial hierarchy that followed, helped shape today's racialized carceral state. And it invites us to look to the future to imagine a society without a carceral focus on punishment. In a criminal law course, we would learn about abolition right alongside other theories of punishment, retribution, rehabilitation, incapacitation. Abolition moves us away from prisons, policing, and prosecution. And it invites us to think critically and dynamically about the conditions that cause crime and inequality. Abolition focuses on finding new, restorative ways of addressing wrongdoing and then ensuring safety. This is not a new concept. The modern prison abolition movement coalesced 20 years ago with the foundation of critical resistance and with Angela Davis's 2003 publication, Are Prisons Obsolete? However, these ideas have spread as lawmakers, scholars, organizers, even lawyers begin to question mass incarceration, and they have spread to other disciplines outside of criminal law. As Ruth Wilson Gilmore explains, abolition is deliberately everything-ist. It's about the entirety of human environmental relations. Gilmore, a geographer by training, recognizes that prison abolition would force this country to address environmental toxins, employment and educational opportunities, childhood trauma, housing, and mental health resources. Our reliance on prisons and jails and detention centers is not a sustainable form of social organization. These concepts gained greater urgency this year and in this school in the wake of George Floyd and Breonna Taylor's murders, and from the murders of countless other Black people at the hands of law enforcement. This country's mass demonstrations for Black Lives Matter encouraged all of us to think critically about combating structural racism in all sectors of society. I'd like us to now consider abolition as a remedy to harm. An abolitionist framework allows us to look beyond existing law toward models that enable repair and prevention of future harm. Abolition enables us to craft tailored remedies that fit the harm experienced. The remedy sought may differ depending on the nature and extent of the harm and the desires of the persons or the communities who experienced harm. Examples of these models already exist in communities that have experienced state violence, and I'll highlight two briefly. In response to decades of police torturing Black people in Chicago, activists and lawyers demanded and then received reparations from the city. They used the term reparations to hearken back to this history of enslavement and a racial hierarchy. In addition to monetary compensation, they secured psychological counseling for all of the torture survivors, an official apology, tuition-free education at a local college to torture survivors and their families, a requirement that Chicago public schools teach this history about the torture cases, and the construction of a public monument that recognizes the torture victims. Chicago's reparations resolution can serve as a model for other communities. In Los Angeles, LA for Youth activists are engaged in a campaign to redirect monetary resources away from policing and into prevention and intervention strategies that include employment opportunities for young people and to provide them skills to enter the workforce. This is an example of justice reinvestment, a term that Allegra McLeod uses. This is what we mean when we say defund the police. It is disinvestment followed by thoughtful reinvestment with an eye toward preventing and mitigating future harm. Beyond reparations and divest, invest, abolition allows for reckoning and reconciliation as remedies for past harm and to prevent the cyclical reoccurrence of future harm. Police violence against Black people is a symptom of a larger illness. And that illness is the presumption of criminality and dangerousness that society, this nation, assigns to Black people. This presumption emerged from slavery and the racial hierarchy that followed. And it's what Isabel Wilkerson explains in her recent book, Caste. Bryan Stevenson, the founder and director of the Equal Justice Initiative, is deeply engaged in a campaign to acknowledge racial terrorism and to provide pathways toward reconciliation. My former boss, Sheila Eiffel, she's president and director counsel of the Legal Defense Fund of the NAACP, has called for racial reckoning to enable reconciliation of long-standing harms that whole communities of Black people experienced as a result of state-sanctioned violence in the name of white supremacy. The adversarial criminal legal system, where assuming responsibility for harm is disfavored, is ill-equipped to acknowledge this reckoning and reconciliation. As Rukia Lumumba explained, we must look to alternative models that focus on accountability rather than punishment. To meaningfully address harm, to protect and advance the rights of racial minorities, and to prevent harm from reoccurring, we must look outside of existing laws. I offer abolition to you as a pathway toward justice. Thank you. And I'm happy to take questions if we have any time.
Thank you so much. We do have time for at least one, probably two questions. So I'll start off with a question that had been in the chat about what can we do to invite people into movement lawyering and into addressing issues like mass incarceration, abolition, instead of towards corporate law or other avenues of law.
Yeah, I think, specifically at Columbia Law School, I have a reading group this fall on movement lawyering, a social justice critique. And it creates a space for us to think critically about the role of lawyers in movement work. And it starts by normalizing this as a pathway for practice. I bring practitioners that are movement lawyers. I bring organizers that work with lawyers, sometimes at legal organizations, sometimes not, into class to talk about the work that they do. And what we focus on in this reading group, which is not necessarily the focus of law school, is on decentering ourselves as lawyers and decentering the law is the primary avenue for change. It's a humbling experience to be a lawyer in social movements. Sienna Fontaine is the legal director of Make the Road New York. And the legal aspect of that organization is really secondary to the organizing work. That's along the lines of immigration work, access to housing, access to healthcare, public demonstrations. So the lawyers, do know your rights training on what happens, if you're arrested at a public demonstration. It helps provide information on navigating systems of public health and immigration, as opposed to filing maybe an impact, lawsuit. And so in this class, we look at that model of impact litigation. We look at the model of sort of decentering, responding to, partnering with, listening to, following the needs of community members. And so much of it, the beginning, is really about bringing these conversations into the law school setting so that we're aware that this is a way one can use their tools and skills as a lawyer.
Well, thank you so much. I just want to thank you and really everyone who has spoken the past 2 days, your speaker, panelist, moderator. I know that, as you mentioned, Professor Hoag, this has been a long time in the making, and it's required a lot of flexibility on everyone's part with format changing and all of that. And I know on behalf of the entire journal, we're all just very, very thankful that you've all been able to have this conversation and share your insight with all of the attendees. And so with that, I'll leave it to Nico to finish this off.
Thank you, everybody, our panelists, our attendees, our journal staff, last year's journal staff as well. Just thank you for creating this space. It's been fantastic. We've gone through this journey together on examining how the law underdeveloped racial minorities in the United States. We've strategically centered our panels and discussions around one-on classes because so many students and students of color like myself felt that our legal education had a gap in it due to the omission of a discussion of race. Today and last night, our speakers helped bridge that gap. Throughout our symposium, we've discussed a reimagination and a restructuring of the systems of power embedded in the legal system of the United States, both today and at its inception. As we conclude and move forward, I simply ask each of us to continue this reimagination, to continue this movement building. And then as we each play our individual role in bringing a new meaning to the unfulfilled promise carved out on the Supreme Court, equal justice under law. Thank you all. We appreciate you spending this time with us, and you will all be receiving the recording once it is given to us. Thank you so much again. Join me for a round of applause for our speakers. Thank you.